Today, inside Judge Raquel West's courtroom, justice takes the spotlight once again. One by one, defendants face serious charges, ranging from theft and assault to deeply troubling child-related cases. Each person stands before the bench, confronting the reality of their choices and the weight of accountability that follows. But this isn't just another day in court. It's a close look at how truth, responsibility, and the chance for redemption meet under the famed guidance of a Texas judge who believes in fairness, yet never ignores the facts. In this courtroom, every word matters, every decision counts, and no one walks away untouched by the lesson.
The only thing that I would add, Judge, is that we now have an agreed restitution figure
That's
for the court.
my question.
Yes.
What is it?
$60,000.
Okay. All right, ma'am, you are Sydney Lewis. And Ms. Lewis was previously here in cause number 24 DCCR 1905, entered a plea of guilty to the third-degree felony offense of theft of property. I've received the pre-sentence report. Have you both had an opportunity to review that report?
The defense says, Your Honor, we have no objections. Yes, Judge.
And Mr. Smith, any objections or corrections?
No objections.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 10 years. You are ordered to follow all of the rules and conditions of probation, and that includes paying back the restitution of $60,000. If you do all of that, this is an excellent opportunity because you don't have a felony conviction on your record. And if you successfully complete the probation, you'll never have a felony conviction. The case will be dismissed at the end. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, you could be found guilty of the offense, and you could go to prison for anywhere between 2 years and up to 10 years. Do you understand? Also, $60,000 is a lot of money to pay back. And sometimes what people will do is they think, I'm going to wait and I'll pay a little bit next year when I get my tax return, and maybe I'll sell this in a year or two, and I've got 10 years, so I've got plenty of time. You will be surprised how quickly that time will pass. And at the end of the probation, you could have done every other thing correctly. And if you don't pay that restitution, and I make a finding that you could have, you can still go to prison for up to 10 years at the end and your probation be revoked. So I want you to pay something on the restitution every single month, because even if it's not a huge amount, it will add up over that time frame. Does that make sense? All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You just need to have a seat here in the courtroom. When probation's ready to go over your paperwork, she'll call you up to her desk, all right? Good luck to you, ma'am. Thank you.
Thank you, Judge.
And then you've got a David Melanson, Mr. Crenshaw.
Yes, sir.
Good morning, sir. Are you TJ Landry?
Yes,
And will your client waive the formal reading of the indictment?
he will, Your Honor.
Mr. Landry, in cause number 24, DCCR 0165, you're charged with the state jail felony offense of theft from a person from December 9th of 2023. And how do you plead to that charge?
Yeah,
You either did it or you didn't do it. Are you guilty or not guilty? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? Speak out loud, please. I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
It looks like the agreement that you've reached is for a 3-year deferred probation. There would be a $300 fine, and you would be required to follow all of the rules and conditions of probation. Do you understand?
Yes, ma'am.
And is there any restitution?
No, the shoes were recovered that
Okay.
day.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Landry is not
No,
competent?
Your Honor.
And Ms. Malfino, with regard to waiving pre-sentence report, is there any issues with regard to history I need to?
No, Your Honor, it looks like there may be some misdemeanor contact, but he has no history. I have no.
All right, so what I'm going to do, Mr. Landry, is waive the pre-sentence report. I'm going to find that you entered your plea of guilty freely and voluntarily. find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for a period of 3 years. You're ordered to pay the $300 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have a felony conviction on your record. And if you successfully complete the probation, at the end, the case is actually dismissed. You'll never be a convicted felon. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, you could be found guilty of the offense, and you could be sentenced to the state jail prison for up to 2 years. Do you understand?
Yes, ma'am.
All right, I've handed you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. In just a few minutes, probation's going to call you up to go over your paperwork. She's sitting at that desk right there, so watch for her to call your name, okay?
Yes, ma'am.
Good luck to you, sir. Yes.
Sorry to interrupt.
Hang on.
Just, since we're waiving the PSI, may I ask two requests of the court that one, he be trespassing from Parkdale Mall, and that he not be allowed to have any contact with a Jalen Nixon or Reginald Guillory.
All right, so I'm going to order as a condition of your probation, Mr. Landry, that you are not allowed to go on the premises of Parkdale Mall. That'll be a part of your probation. Also, you are to have no contact or communication with Jalen Nixon and tell me the other name? Reginald Guillory. So that means in person, y'all can't hang out, but it also means any other way. You can't send messages, you can't Snapchat or DM or anything like that. You go live your life, and whatever they do, they need to live theirs. Make sense? All right, you can have a seat. Thank you, Ms. Malfino. And then, Ms. Holmes, you have Edmund Latulis.
Edmund A.
Okay, we're going on a lesser.
Yes, ma'am.
And this is Mr. Coleman's on Deshauna Bass. Good morning, you're Deshauna Bass? And will she waive the formal reading of the indictment?
She does, she does.
And Ms. Bass, in cause number 24 DCCR 2316, the state has elected to proceed on the lesser included offense of a Class A misdemeanor assault from October 27th of 2024. And how do you plead to that charge? And are you pleading guilty freely and voluntarily? And because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 2-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? And are you a U.S. citizen?
Yes.
State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Ms. Bass is not competent?
No.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney. Defer all proceedings and place you on probation for a period of 2 years. You're ordered to pay that $500 fine and to follow all of the rules and conditions of probation. If you do that, this is a great opportunity because you don't have a conviction on your record. And at the end of the probation period, if you successfully complete it, the case is actually dismissed. You'll never have a conviction. The other side of that, though, is if you violate any condition of your probation, you can be brought back into court, found guilty of the offense, and sent to the Jefferson County Jail for a period of up to 1 year. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation's going to call you up in a few minutes when she's ready to go over your paperwork. So she's at that desk right there, so be watching for her to call you up, okay? Good luck to you, ma'am. Thank you.
Thank you.
Thank you.
And your signature's not on that.
Yes, ma'am.
Yes, ma'am. Good morning, ma'am. You're Edmund A. Latulis. And will your client waive the formal reading of the indictment?
She will, Your Honor.
Ms. Latulis, in cause number 24 DCCR 2057, You're charged with the state jail felony offense of abandoning or endangering a child, and that is from June 14th of 2024. And how do you plead to that charge? And are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them? Speak up, please.
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement that you've reached is for a 5-year deferred adjudicated probation. There would be a $300 fine. You would be required to follow all of the rules and conditions of probation, including any referrals for any type of emotional support or counseling that you need. Is that your understanding?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation? Mr. Frazier, can you hold it down, please? That your plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law. State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Latulis is not
No,
competent?
Your Honor.
And
Judge,
do we need to get a PSI just so we know what all needs to? I think so too. All right, ma'am. So I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so the probation department can do a pre-sentence report. That'll just give me more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right there, okay? All right, we'll see y'all back at sentencing. Thank you.
If you enjoy watching real courtroom justice unfold, don't forget to hit that subscribe button and turn on notifications. Every week, we bring you authentic cases, real judges, and real outcomes. No actors, no scripts, just the truth as it happens inside the courtroom. Stay tuned, because what's coming next shows just how quickly a second chance can vanish when the wrong choices are made.
Good morning, how are you? Yeah. Oh, nice. It's hard to feel sorry for you.
That's tough.
Did you? Yeah, I feel zero sorry for you right now, but thanks for sharing.
Negative.
Negative. All right, sir, you're Ryan Eric January. Speak up, please. And Mr. January, in cause number 25 DCCR 0370, was previously in court, entered a plea of guilty to the third-degree felony the state jail felony offense of solicitation of prostitution. I've received the pre-sentence report. Has everyone had an opportunity to review that report? Any additions or corrections? So I guess I had a question. I did not realize if we do this on all or if this, but it's showing a requirement to be on the sex offender caseload. But this is not that type of offense. It's not registrable. And so I don't believe that we have been doing those or.
We have.
I'm sorry. Okay. Yeah, I want to rescind that unless there's some reason specifically in this case that there's different you can get with me. Another thing, so I'll take that out of the orders at this time, and then if there's any issues, then we'll make sure everybody knows about it and we'll get back together. The other thing, Mr. January, that is I'm going to order as a condition of your probation is that you get your GED. It is very important to me. It should be important to you. It will help you do better, get better jobs in your life, and so it's going to now be a condition of your probation that you start that process within 30 days of today, okay? So you talk to probation, they'll let you know how to get started on that, and you need to get started on it, complete it, and that'll be at least a good positive thing that happens out of all of this. So again, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm not going to do that. I'm going to follow the agreement, defer all proceedings, and place you on probation for 3 years. You're ordered to pay a $500 fine and to follow all of those rules and conditions of probation. If you do that, this is an excellent opportunity because you don't have this conviction on your record. And at the end of the probation period, if you successfully complete the probation, the case will actually be dismissed. You'll never have a conviction on your record. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and be sentenced to the state jail prison for up to 2 years. Do you understand? All right, I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation, she's going to call you up to your desk when she's ready to go over all of your paperwork. Good luck to you, sir. Thank you, Mr. Rennick. Thank you, sir.
Morning.
Good morning. Good morning, sir. You're Donald Owens, Jr. And Mr. Kelly, will your client waive the formal reading of the indictment? Sorry, it's going a little slow. It's stopped spinning now. Oh, there, shut up. All right. Mr. Owens, in cause number 24, DCCR 1192, you're charged with the second-degree felony offense of sexual assault of a child from March 29th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And because they you did what they charged you with. I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kelly? And do you fully understand them? And my understanding is there is no plea bargain. This is just open to the court. Is that correct?
That's correct.
And that there is, in addition, not a waiver of the right to appeal because of that as well, correct?
That's correct.
And is that your understanding? That I want to make sure you understand, Mr. Owens. Obviously, you know your case is set for trial to begin with jury selection this afternoon. You have every right to have that jury determine if you're guilty and what your punishment is. If we go forward this way, you're pleading guilty and you're leaving your punishment up to me. And is that what you want to do? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
Objection, states 1.
It's admitted. Is there any evidence that Mr. Owens is not competent?
There's not.
In addition to that, Mr. Owens, you do understand that as a condition of your plea in this case, that you will be required to register as a sex offender. And I have that document that you've signed with Mr. Kelly, and y'all went over that this morning, and you understand it. All right. Then I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right over there. So for sentencing, since it's unagreed, do you guys anticipate lengthy hearings, witnesses? What type of time frame do we
Expect
need?
us to call witnesses, Your Honor.
Okay, any more than an hour's worth? Something we could do at the end of a docket? Or do y'all anticipate more
I
than
don't
that?
anticipate any more than that, Judge. We may have one witness,
Okay,
but I don't want to confine us to that. If it goes over, we only have, I only expect.
no,
one
I mean, I
witness.
want that, well, that's what I want to
Yes.
figure out, is if you anticipate that it could be longer than that, then I can set it on a date other than a Monday, when we don't have a trial or something like that. But if you think y'all can get it in at the end of a docket from 11 to 12 or,
If the court can consider not putting it on a Monday, that's what we would ask for.
okay, all right, we'll take a look at appropriate date for that and let y'all know that court date. Obviously, anything you think is important for me to know, get that information to Mr. Kelly, and then I will look at all of that and listen to everything when we come back. All right, don't forget to stop and talk to probation. Thank you.
Your Honor.
Thank you, Judge.
Good morning. Good to see you.
You too.
Sorry
That's all right.
about the case.
Good morning, sir. You're Timoteo Castaneda? Yes, Mom. And in 25 DCCR 0360, Mr. Castaneda is charged with indecency with a child by sexual contact. And what is the announcement?
Judge, if we could come back, we're very close. We're trying to get a probation offer, and once we get that, this will be resolved. We're just not quite there just yet. I think we've only been here once.
Well, it looks like you were hired in May, so this will be the last reset on this case. So, Mr. Castaneda, make sure you stay in touch with Mr. Crenshaw so that any information he gets from Mr. Hoffpower, you guys can go over, and we'll get an announcement at that next court date. All right, thank you. Catherine Jordan.
If we could just come back on a standard reset. She was trying to get the full restitution, and the good news is she has that. And
So I can set it on an actual plea docket, and y'all will get it taken care
Yes.
of on a plea docket?
yes.
Okay, then I will reset it to a plea docket. Obviously, once it's on that plea docket, I expect it to enter a plea on that day. If anything changes before then, just let me know.
We sure will.
Stay in touch with Mr. Crenshaw. He'll let you know when you need to be back, and we'll take care of that. All right, thank you. Let's see, and you have a... Good morning, sir. You're David Melanson? And this is 24 DCCR 1186. Mr. Melanson is charged with assault on a family member with previous convictions. And is there an announcement? It looks like you were just hired on this one.
I was, Judge. We're actually on the next setting, I think, going to the state's going to subpoena the complaining witness.
Okay.
And I think we'll have a resolution on that date.
Okay.
And I have not heard from her since June of 2024, Judge, but if you could would allow
Sure.
me maybe 30 days to send a subpoena.
Yeah.
And Mr. Crenshaw has also presented me with information that he believes there's a non-prosecution affidavit, so we're both going to try to get our hands on that.
Okay, so I'll just do a normal reset to give y'all time to get that taken care of. Make sure you stay in touch with Mr. Crenshaw. He'll let you know when you need to be back. All right, thank you. Let's see.
In this full courtroom session with Judge Raquel West, justice played out in powerful and deeply human ways. Every case told a story, some of loss, others of second chances, but all showing how a single choice can change the course of a life. The Feist case was Sidney Lewis, convicted of theft of property. Judge West handed down 10 years of probation and ordered $60,000 in restitution, reminding everyone that financial crimes don't just empty bank accounts, they can leave lasting damage to a person's name and future. Next came T.J. Landry, charged with theft from a person. His sentence, 3 years of deferred probation and a $300 fine. The judge made it clear that while money can be replaced, trust takes much longer to rebuild, and every action has weight. Then there was Disabase, found guilty of misdemeanor assault. Judge West gave her 2 years of deferred probation and a $500 fine, emphasizing that learning self-control is often what separates a mistake from a life-changing outcome. The tone shifted when Edmund Latchless stood before the court for endangering a child. His sentence, 5 years of deferred probation and a $300 fine, reflected accountability paired with a chance to rebuild. The message was simple: the court believes in growth, but not without responsibility. Ryan Eric January faced a solicitation charge. Judge West imposed 3 years of probation, a $500 fine, and ordered him to earn his GED. This wasn't just a punishment, it was a push toward self-improvement, a reminder that real reform begins with effort and education. Things grew more serious when Donald Owen Jr. appeared on a sexual assault of a child charge. Judge West reset the case for a pre-sentence report, underscoring that such serious matters require careful review before final judgment. Every detail, every fact, must be handled with precision and fairness. Tomato Castaneda's case, involving indecency with a child, remains pending as both sides work toward a possible probation deal. It's a pivotal moment, one last chance to accept responsibility before facing trial. Finally, David Melanson stood before the court on an assault charge involving a family member, with prior convictions already on his record. His case was reset for further evidence review, showing that while justice may take time, it still arrives, steady, deliberate, and fair. Across every hearing, Judge Raquel West's approach stayed consistent, firm but balanced, compassionate yet uncompromising. Some defendants walked away with a second chance, others left knowing that their hardest test was still ahead. In the end, this session was a powerful look at accountability in motion. Every person, every sentence, carried a message. In this courtroom, honesty and effort matter more than excuses. If you found this breakdown as revealing and powerful as we did, don't forget to like the video, subscribe, and share it with others who value real justice. Because hey, every case is real, every consequence matters, and every judgment tells a story.